It's especially nice to be back. I came down to do the conference on sexual misconduct on campus on the main grounds, but I really came because it was a chance to come back to the law school. So I immediately got in touch with the dean and asked if I could drop in while I was down here. So I'm grateful to him for that and to you for coming. It's a very special thrill. What I've been asked to talk with Anne, who introduced and did one of my panels today, with another former prosecutor from Philly, an interesting day, asked me to talk about the career, and so this is going to be a little more autobiographical and obnoxious than probably anybody wants to hear, but it'll launch me into what you may want to talk about. I always start, as I did yesterday in the keynote on Main Grounds, with a little bit of the history of sexual assault crimes and laws. When I came to this law school in 1969, I had just graduated from Vassar, which was then a women's college. The undergraduate part of this university was still an all-male school, which just stuns me as a state university to this day. This law school was at Clark Hall, across town. Professor Bonney was a young kid, maybe 2 or 3 years out of a school ahead of me. And John Jeffries was a year behind me, really a kid. And there were, I think we started about 16 women in my law school class, which was radically raised from the 6 who had been the maximum in the classes before me. And we finished with 10 or 11 of us. I mean, we lost the first 6 at the beginning. The dean was a wonderfully remarkable man named Monrad Paulson, who is actually responsible for my career, and the former dean, Hardy Dillard, probably the best voice I ever heard in a classroom, was my contracts professor. And we used to have a thing, I'm sure it's no longer here, but called Ladies' Day, where we would walk into class and 150 of us in the large section, and you just didn't know what day it was going to be, and Professor Dillard would say, "It's Ladies' Day," and the 3 of us in the class would have to stand for an hour. I would turn about the color of this jacket and had to stand the whole hour and just be the 3 people who answered questions. It was horrible. It was Dean Paulson, who then had written the textbook on criminal law and procedure that was used here and in most other places, who really took an interest in me as a student. I was very interested and engaged in those issues from the time I first got to school here. I'd wanted to be a writer. That's what I grew up with as an ambition, and I used to say when everybody would come to dinner at the house, Aunt Mary and all the other relatives, "What do you want to do when you grow up?" And I'd say, "I want to write novels." And my father would roll his eyes and say, "You have nothing to write about. Get a job, get a career." And my other interest was public service, which is really what launched me coming to law school, was the idea to do it. But I no more thought of public service being litigation or working in a prosecutor's office because, like many careers for women in those days, prosecutor's office and litigation was not a very open door. And it was Dean Paulson who opened that door for me. The New York County District Attorney was a man named Frank Hogan. He was, at that time, a legend in law enforcement. He'd been DA for 28 years. But he didn't allow women in the courtroom in his office. He had 7 women on a staff of 200, and he thought the law library was the appropriate place for us to be. As he said when he interviewed me, this is the work about blood and guts and violent crime, as he said, were just not appropriate for a woman of my educational background. And so I was thrilled to be offered the opportunity to work in the Appeals Bureau doing appellate work on all the serious cases. The first time I ever tried to be a spectator in a homicide trial in New York in 1973, when there were still all-male juries in many states, New York included, I was called down to his office and told that it was, again, totally inappropriate for me to be in a courtroom where people were discussing violent crime, and the witnesses in the case actually were prostitutes who'd been killed in a brothel on 57th Street and Park Avenue in a very high-rent part of town. So things changed rapidly after Frank Hogan's death. He was a wonderful man, but the office changed, and Bob Morgenthau became district attorney. Mr. Morgenthau retired a few years ago at the age of 90 and is still practicing law at Wachtell Lipton. 94, and with a very vigorous mind and remarkably good health. He had been U.S. attorney in the Southern District of New York, fired by Richard Nixon, and then after an unsuccessful run at office, took over the Manhattan DA's office and had entirely different attitudes about diversity of all kinds and about who should people his courtroom. By that point, 1972 saw the creation of the first special victims units in police departments, first in LA and then in New York City. There had not been any such institution anywhere in the country. The Manhattan DA's office was the first to create a sex crimes unit. When I took it over 18 months after its creation, there were 4 lawyers in the unit. When I left in 2002, 30 years after I started, there were 45 lawyers in the unit doing this work. So the nature of the office changed altogether. The face, diversity again of every kind, it changed. The laws were so archaic when I got out of law school, when other people, not just me, but I'm referring to my period of time, when I got out of school in 1972, the laws were so archaic that the word of a woman reporting a sexual assault was deemed by the law to be legally incompetent. That was the language of the law. There had to be independent evidence beside the victim's word in order to take her into a courtroom. So in 1970, there were more than 1,000 men. There were 1,100 men arrested in the 5 counties in New York for sexual assault. 18 of them were convicted. And the 18 were convicted not because lawyers were taking victims, mostly women then, into the courtroom and losing cases. We just had to tell women who presented that the evidence didn't exist. And just for a moment, the 3 pieces of evidence required for corroboration under the law were independent evidence of who the attacker was. So here's a crime that rarely occurs with any witnesses, certainly not eyewitnesses, and you had to have therefore someone who had seen the assailant going to the crime scene or leaving the crime scene, or actually witnessing the crime. And bank robberies happen in broad daylight, lots of shootings and homicides do, but sexual assault rarely does. So that element had to be proved, had to be proof of the sexual nature of the attack. Now, you all know the expression evidence collection kit, and they're in every hospital and most doctors' offices in this country. They didn't exist in the early 1970s, so it was very rare for a victim to be treated and examined in a medical setting where anyone had collected evidence. Little aside on that, the evidence collection kits are known in the business as Vitulo evidence kits. And so when I met my first cardboard box that was a Vitulo kit, I assumed Dr. Vitulo was a biochemist somewhere who'd come up with this wonderful idea to get evidence safely from an examination to a police lab. Charlie Vitulo was a sergeant in the Chicago Police Department who was one of the early believers in special victims work, had no support to do it, and he just collected shoe boxes, that's why the boxes are cardboard to begin with, collected shoe boxes from his wife and all her friends and kept them in the trunk of his car so that he could give them to hospitals. It was the only way to get physical slides, glass slides from the hospital under wrap to a lab, and they are still named in Charlie's honor. So you needed evidence of the sexual nature of the attack, and you needed evidence independent of the victim of the forcible nature of the attack. So assume for the moment that the assailant was a stranger and there was a weapon involved. If that stranger was identified in a lineup 2 or 3 weeks later but did not have the knife or gun in his pocket, on his possession, that woman was deemed to have consented to the assault because the weapon was not on his person when he was arrested. And if there was no weapon, if she had submitted to a threat of physical force to harm her, to strangle her, to beat her, then again she was deemed to have consented because the only other proof of physical force would have been injury. Not a required element of the crime, but a required element of corroboration of the crime. So all 3 of those factors had to be in place in order to take a woman into a courtroom. That's why there were only 18 women in the preceding year to my arrival who were able to go forward. So when I got to the practice, it had never been my thought that I would have any role in reforming any kind of prosecutorial law or anything having to do with violence against women. It was a field that had actually emerged in the 1960s, but entirely, sadly, entirely outside of the criminal justice system. You can look to Ms. Magazine and Gloria Steinem and feminists as the first people who wrote about these issues. And for me, looking back as a lawyer, I think it's a sad commentary that neither judges or lawyers within the system were the ones who created the movement to change things. And so the people around me began to agitate for change. And for me, it was a fortunate thing of being in the right place at the right time. My movement in 1973, after my first year in the office, to do special victims work to handle the rape cases was, again, entirely accidental. It's anecdotal, but I will just tell it. There were only 11 people in my entering class, 10 guys and me. Though the bravest of those guys agreed to share his office with me, which was a radical thing to have, to agree to have a girl in the office. He's now, unfortunately, married to the Lieutenant Governor of New Jersey, so he has bigger problems than that on his plate at the moment, but he is a wonderful guy and married to a very smart lawyer. We'll see where that goes. And so we were actually rated. We were in a bureau that only did indictments. In the old days in Manhattan, before the structure of the office changed, your second rotation in the office was to present cases to the grand jury. That's all we did for an entire year, morning to night. 6 grand juries sat. And we were rated. We got our year's evaluation for the maybe $500 bonus that we got or not, based on how many cases we could present a day to the grand jury. And so the room consisted of chairs, about that size, chairs twice over, and a desk 10 times as long as this, and 6 or 7 of us would stand behind the desk at one time, and police officers would come up one at a time and present their cases to us. And if you were a really smart guy, you would want the police officers without civilian witnesses beside them because they were pretty good at testifying, and mostly they were the cops who had gun arrests and drug arrests. So no civilians, they knew the drill, they had a lab report. You could talk to them, debrief them, put them in the grand jury, and be done in about 8 minutes' time and have an indictment for a felony. It was great. The rape survivor would show up with a police officer. She would be in this vast room of blue uniforms and a few other civilians. And the plan would be to have to talk to her right in front of this table with everybody else around. And since I was the only woman in the group, no more sensitive than any of the men around me, because I didn't know the first thing about sexual assault or how to talk to a victim, as they were then called, or survivor, as some choose to be called now. And the guys just had the clever idea of thinking, give it to the woman because she'll be more sensitive with the victims than we will. I mean, I knew what a scam it was. These are all my pals, but it meant that I would have to take the survivor out of this setting, go back to half a hallway away, get her into my office, make her comfortable, explain the law, how bad the law was, the fact that maybe if she testified and there was some corroboration, we could get an indictment, and maybe we couldn't. And then come back, and by the time each of my colleagues had presented 6 or 8 cases to the grand jury, I would be lucky if I got the one rape survivor in. And that was the way I spent that year of my life. And it had the quite surprising effect of stirring something inside me that connected to these cases. And it was quite an exciting time to be doing the work because the change was just beginning to occur. And so within the next year, as the first parts of corroboration were eliminated, it was eliminated in stages over years, it became possible to take these victims who came in expecting nothing, who previously you'd been able to do no justice for, and get them first into the grand jury and then into the courtroom. And so the work was really very fulfilling for me, and I found it much more interesting than doing drug cases or doing car thefts or burglaries, and it was almost ironic because it had been foisted on me as something everybody thought I'd want to get rid of as soon as I could. When Mr. Morgenthau took over a year later, he asked me to take over this newly formed unit. And he did it despite my young age because he wanted a signal to the community that if you put a woman in charge of these issues, perhaps women, who were the overwhelming number of victims, would choose to come forward. And I said no. I told him I did not want to do it because I thought it would be too depressing, actually, to do that kind of case and be met with resistance all the time. And I got about 20 feet out of his office, and I was stopped by the chief assistant, who's a federal judge in the Southern District, John Keenan, who would be a great guy to work for and learn from. And John Keenan took me aside, and he said, in the words of The Godfather, this is an offer you can't refuse. That was the big movie at the time. He said, the DA was not asking you for a yes or no answer to the question, will you take over this unit and run it? You say yes to him. And he said, turn around, go back. I was out of the office maybe 30 seconds, and I went back in and said, Mr. Morgenthau, I've been thinking about what I said to you, and obviously it was a great offer, and I meant to say yes. And he joked, and he said, I'll give you 2 years, and at the end of 2 years, you can do anything you want in this office. Homicides, which were the elite unit, it was always all male, it was always the macho, the biggest cases in the unit, in the office, and everybody wanted, you can do homicides, you can do whatever you want, just come to me at the end of 2 years. And 15, 18, 20 years later, we'd pass in the hallway and he'd say, you ready? You ready to get out? It was the work of that unit that kept me there. And so not only the opportunity to affect change, along with many, many other people, women and men who became involved in the movement, the rape shield law. When I first started prosecuting and when I tried my first several cases in the early 70s, as hard as it was to get in the courtroom, victims were allowed to be asked on the stand about their entire sexual history. So if a woman was married and a stranger came through the window and held a knife to her neck and her husband was still at work, she would be allowed to ask how many different people, just a fishing expedition, no evidence necessary by the defense attorney, but he would be allowed to go into when she lost her virginity and how many other people she had had an intercourse with before this event happened. On the theory, as he could then argue to a jury, that if she was previously unchaste, the likelihood that she would consent, even to a stranger coming through a window, was great. And so that's how victims were treated in the courtroom throughout the mid-1970s. So rape shield laws, which probably most of you have heard from, were put in place to protect victims, to encourage more of them to come forward, and to allow them to get on the stand without that kind of fishing expedition. There are very reasonable exceptions carved into that that protect defendants, so that if it's, for example, an allegation in which the accused has previously had a sexual relationship with the victim, he's entirely allowed to go into that relationship. If she claims she became pregnant as a result of the rape from him or contracted a disease, he's allowed to attempt to prove otherwise. So the laws were pretty carefully carved, but did an enormous amount to protect those victims. The next big change in 1983 was the earnest resistance requirement. It was still part of the law up to 1983 in New York that if a victim confronted an attacker and he had a weapon, she was required by law to resist. She was required to fight and had to have some kind of proof that she had fought, usually in the form of an injury, or else she was deemed to have consented. And we had to try those cases, which were pretty ugly when there were weapons involved, and did not get that law changed till 1983. By that point in time, I think the other two fronts that really began to emerge under our umbrella were child abuse, which continues to have problems that the criminal justice system will never solve entirely, that have to do with the developmental ability of child victims and what they're able to testify to, what they're able to remember and recall. But at least we were able to get on the map and in the courtroom, and again began to think of creative legislative reform that would protect defendants who were charged with the crime, but enable many more children to get in. Domestic violence was probably the hardest area of work in which to change attitudes. The laws are pretty much in place, except for rape, but if you beat someone, whether or not you're married to them, you killed someone, those crimes are assault or they're murder, and they were on the books. Marital rape, as most of you know, was not against the law in almost any state in this country till the mid-1980s. And so public attitudes about the crime were terrible. It was very common in the 1960s and 70s for a prosecutor and a defense attorney to stand in front of the judge, and the prosecutor was as likely as the defense attorney to argue that it was only a domestic, and the word only was emphatically used. The most common remedy then was for the judge to release the offender. Very few were held on bail except for murder cases, and release them in the custody of the police officer and order the officer to have a cooling off period. Walk the guy around the block for a couple of times before you let him go home. You just need to cool him down, and then everything will be fine. So the rising number, the escalation in homicides throughout the 80s and early 90s that were intimate partner violence began to get the attention of victim groups, the media, and I think eventually then forced some changes in the law and in thinking. But and then the more creative work began when prosecutors, particularly a very creative prosecutor in San Diego who started a movement to handle domestic violence cases without the cooperation of the victim. So when victims chose to withdraw from the system, even after 4, 5, 6 beatings, attempts to leave the offender, which, along with pregnancy, are the most dangerous times in a relationship, you could prosecute the case using 911 records, medical records, the neighbor who heard screams or calls the police officer who observed the beating. And what we try and do as prosecutors is assess when that victim, even though she's choosing not to cooperate, or her children are at such risk to harm that you, the state, make a decision that's a very tough one to make about whether you should prosecute without her cooperation. Stalking, there were no laws on the books at all until the late 1990s. The word stalking was not used in the criminal justice system. It was a patchwork of crimes. People would say they were harassed by an offender, they were followed by him. This is before we even get to the cyber world. But again, until we had enough episodes of extreme violence, stalking was not legislation in any state in this country, and that came to be addressed and changed in the late 1990s before the entire world of cyber crimes developed. Human trafficking, we had trafficking cases in every prosecutor's office. It's a practice hundreds of years old. It is as common with domestic victims as it is, more the literature concerns women and men and children brought from various areas around the world, but there's as much of it within state to state, and we always saw a lot of it in Manhattan, but nobody put that name to it, and there were no efforts to address it really on a criminal level as a separate crime with its own penalties. That really started to happen in the early 2000s, and now most prosecutors in the offices in the country have made efforts to deal with trafficking. The federal government has legislation as well to deal with it. I think certainly the most unexpected development for me throughout the work, and the one that most revolutionized the work that my colleagues and I did, was the introduction of DNA technology. I was first heard of it, was asked to look at DNA as a scientific technique in 1986 when I was prosecuting a murder case. And in that murder case, the victim and offender knew each other, and she had been suffocated and strangled using a piece of her own clothing. So the chief medical examiner in New York called me and said, there's a new scientific technique. He said, I don't know anything about it. We don't have anybody that does it. There's only an FBI lab in Quantico that's doing it. They're only taking a handful of cases because it's laborious work and it hasn't been accepted in any court in the country yet. We called Quantico, asked them if they would consider the evidence in our case. We were trying to prove that the victim's saliva on her clothing and blood from her mouth, the only place that she bled, would confirm that the clothing was placed over her mouth, and the only place the defendant bled was from his hand, because she had bitten him while he was trying to suffocate her. So we had this very unique piece of clothing. I had the advantage, the FBI said, well, we'll only take your case if we're going to get publicity for it. That's how we're picking and choosing. It was the only time in my career I was glad that the New York Post was in my jurisdiction, a just horrible tabloid. But there were so many articles, the FBI asked for articles, so we clipped thousands of articles about this case and sent them to the FBI. They examined the evidence. They sent us a preliminary result. It took 6 months to get a preliminary result, which I could get for you tomorrow. And the amount of blood had to be larger than the size of a quarter, as opposed to a nano fraction of a corner of a fingernail that we could submit tomorrow. It took 6 months. We got a preliminary result that matched the killer to the victim and to the murder weapon. And we had a 3-week hearing about the admissibility of DNA, after which, with great witnesses. And the judge ruled at the end of it that this stuff was way too experimental and very unreliable, and that we would not be allowed to let the jury hear the evidence about DNA. So they saw the jacket, they could see the blood, they couldn't hear about the saliva or anything other than blood typing and how unique the blood was, because it was considered radically unreliable. It took 3 years, 1989, till we could use DNA in the courts in America. And I think one of the greatest pleasures for me as a prosecutor is that we used DNA for those 3 years and to the present day more often to exonerate than to convict. And it still remains an enormously valuable tool for that. So the last thing I expected was that science would do so much to radically change the piece of law that was what I enjoyed working on the most, and it's changed everything. The public service for me has just been the most remarkably fulfilling work that I could imagine doing, other than, I think, teaching. It is, I still keep my CLEs. I haven't given up practicing law. I do a lot of training with prosecutors. I do a lot of work both on cases for victims of violence and exonerations where I think that someone is wrongly accused of the crime. And the opportunity, I think, as a prosecutor, which so many people think of as, the job to put people in jail, can be more than any other work in that field, a way to do justice and to get out of the system cases that don't belong there. That includes false reporting in this area of criminality, and seeing that justice is done in cases that 30 years ago wouldn't have been anywhere near a court of law. And I still love doing the work. I just got a text at 3 o'clock today from the woman who now runs the unit, who's a kid who trained with me, that a guy indicted in 1999 for a rape of a woman on the Upper West Side, where he posed as a UPS driver and got in and stabbed her repeatedly and raped her and fled the country, has been found and is coming back. And I just texted the DA to ask him if I could try the case, so which I am keenly hoping to do. So it's been a great career. I owe everything to my 3 years here, to the wonderful people at this law school. I know that you probably know, I hope some of you benefit. There's a fellowship in my name. I didn't need anything in my name. I'm not about, we don't need the Fairstein School of Law, but 3 of my classmates who didn't do public service, who went on to use this education, to use my notes to be law review and top of the class. John Jeffries, I called them and twisted their arms, and the surprise to me was that they created the fellowship in my name for students to use for public service. So that gives me enormous pleasure. So be nice to each other, and those of you who go on to great financial success, take care of the ones who do God's work and come into public service.